Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. So Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things you've Father, done you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. See, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything.
Hello, lovely people. It's another wonderful Saturday afternoon, and we're live on BWTV, BW Radio, and on BWF Solicitors Facebook, YouTube, and all the social media platforms. My name is Oriku Sifrimpon, and I am privileged to be your host for this afternoon's Community and the Law. Community and the Law is brought to you by courtesy of BWF Solicitors. BWF Solicitors 214 to 218 Tottenham High Road, Seven Sisters, North London. And we are privileged to say, and also happy to say, that they have provided us as a resource person to look at today's question. And I'm asking you now, you have a son, you have a daughter, you have a child, let me put it that way, who is British and lives abroad. How are you going to apply for a passport for him or her? Now, today also we'll be looking at how to do some calculations. So get your calculators ready, or if you have a pen and a paper, get and ready and sit by the TV, by the computer, or any device from which you are watching us, and I'll be asking you to do some mathematics for me. It's a very wonderful program coming your way, and it's brought to you by BWF Solicitors 214 to 218 Tottenham High Road. Let's say thank you to them, and we'll come back into the discussion right after this.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Welcome to City of Favor Estates, developed by Sarenano and Sons Company Limited, located in Tema Community 25 extension off the Tema Aplau Road. City of Favor Estate offers 2, 3, and 4 ensuite bedrooms on 118, 138, and 178 to 190 square meter lands, respectively, to give you the needed space. Our gated estate homes are designed with you in mind and have all the necessary amenities located in a serene environment with security. You too can be a homeowner at a price that suits your budget with flexible payment terms. Choose City of Favor Estate for peace, comfort, and safety. Reach us on 0542 563 250 or 0243 235 518.
Welcome back, and thank you very much, BWF Solicitors. You've been kind and you have always followed us and giving us the support to get the community to learn all the things that we need to learn. This afternoon, as I said, we're going to do some calculations, and that's coming up next in our nugget. But apart from that, the question I'm asking is, do you know how to successfully apply for a passport for your child who is British and lives abroad? Wherever the child lives, can the child really obtain a passport from that country, and how are you going to do that? Is it, can you do an out-of-country application? Can you do an in-country application? Who does that application? Who can do that? If the documents that are requested, how are we going to provide all those? Lawyer Charles Asma, my guest, who will be taking us through that. But in the meantime, let's get something to learn. We go to our nugget, and that's the information that BWF Solicitors put out earlier in the week. Now, what they're asking us is, what is statutory sick pay? Statutory sick pay is the legal minimum payment staff should get when they are off sick. That is, incapable of work due to sickness or injury. If they meet the eligibility requirement, then definitely they are eligible for statutory pay. Now, for the tax year beginning the 6th of April 2023, the rate is £109.40. The previous rate was 99.35 per week. It is usually payable from day 4 of sick absence. During the COVID pandemic, SSP, that is a statutory sick pay, was payable during periods of self-isolation provided the employee met certain eligibility criteria. However, the laws have now been removed and reviewed. The statutory sick pay general regulations of 1982 is the source of my information. So question is, who qualifies for statutory sick pay, and what is statutory sick pay? I'll be introducing Charles Asma in a moment, and for him to help us do that. But in the meantime, I would want to really pay my dues and tell BWF Solicitors, thank you very much, sirs, for helping me. I'll be right back. Yes, sir.
This is our world. Here we are in our community. There are the laws, there are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, yes, I'm right back. And as I mentioned, this is time for me to introduce my resource person, my guest. And he is our usual teacher, friend, and from BWF Solicitors. I'm talking about Lawyer Charles Asma. Lawyer Charles Asma, thank you very much, and good afternoon.
Good afternoon.
How are you doing?
Very well, thank you. How are you?
Yeah, well, I'm fine. I know people have taken time off their holidays. Carnival is ongoing and the rest of it, but they are listening to us. So we're privileged to, one, have you give us your time, and we're also grateful to our viewers for their time as well. How's work?
Work is fine. We're still making the community happy, meeting expectations, and counting every day at a time.
Well, counting every day at a time. Now, last week when we were on the show and we're talking about representing people at the airport and the rest of it, I got off the show and somebody was like, "Oh, you really enlightened me," because at that time I had information from my friend that they were detained at the airport and they needed a lawyer, and obviously I advised them to contact BWF Solicitors. Thank you for the service to the community. How easy is it to get people away from those things that happen at the airport, being detained, ask several questions, and the rest of it?
Right. So, as we indicated the last time, within the immigration rules and the statutory provisions, the caseworker who is issuing the visa or making the visa decision is one person, and the entry clearance officer who is allowing you to enter the UK physically is another person. What it means is that even if the visa is issued, it can be cancelled or approved. So it has to be approved at the airport at the point of entry. And that's why we call that entry clearance. So you have to be cleared upon entry. Now, once you arrive, they will test the information you provided to see whether indeed they are what you presented. And if they feel that or they suspect false representation or falsehood, then they will take the steps to withhold the entry clearance issued to you from abroad. When it happens like that, it's part of the administrative process. And therefore, you will be questioned, you will be detained, and you will have to go through the process. Now, we pointed out that detention is not a criminal process. It's an administrative process, and therefore the Secretary of State has to go through its own process, her own process. One thing that viewers should be aware of is that once you are detained, you will be there for 7 days. After the 7 days, you have to be granted bail. Therefore, they can choose to let you stay there for the first 7 days. Then after the first 7 days, you have the right to be granted bail. Do I have the right to be granted bail before 7 days? It is not a right. They can choose to let you out on day 1 or between the first 7 days. But after first 7 days, you have to be released on bail, pending the process. And you go through the administrative review. If they still maintain the decision, you have to go through judicial review. That's the court to decide. But the long and short is that if they suspect falsehood or deception, then they will have to question you further. But it is the Secretary of State's duty to prove that indeed deception has taken place and therefore the visa was issued to you wrongly on the basis of the deception you provided. Is it easy to get people out? Insofar as the rules allow, yes.
Okay. Well, as I mentioned, Lawyer Charles Asma last week, strangely we're discussing that and it enlightened somebody. But this afternoon, what we're looking at is something with your employment rights. And that's what the nugget is talking about. And it's talking about statutory pay, statutory sick pay. Now, people really sometimes are they fall sick. You could be injured. You could have any ailment, and for a number of these, you may not be able to attend to your normal duties at work. Do you have to be paid for that? That's what they're saying. What is statutory sick pay? Now, it says statutory sick pay is the legal minimum payment staff should get when they are off sick, i.e., incapable of work due to sickness or injury, if they meet the eligibility requirement. So then I'm going to ask about what statutory sick pay is and what eligibility requirements there are. Lawyer Asman.
Thank you very much, viewers and listeners. So, sick pay is sick pay. It means you are off sick and your employer by duty has to pay you. It is statutory because it is within the law that you have to be paid when you are a staff or an employee and you are unwell. More often, your doctor will have to certify that, especially after the first week. So your doctor will have to certify that. If it's within the first week, then your doctor does not necessarily have to certify that. So that point to be noted. And because it's a statutory provision, the employers are required by law to comply with that. And in this case, you have to show that, yes, you are an employee, you are a staff worker of that organization. You have to, as we have previously indicated, it doesn't really matter whether you are full-time or part-time, you are a staff. What then happens is that depending on the threshold or the number of period you are absent for, as we said, it's week by week. So it's a weekly sick pay. And there is a criteria for calculating that. Before, during the time of COVID, there were other provisions introduced, but because COVID is over, that bit is taken away. So we are not going to discuss the COVID dimensions, because COVID is no longer the case. What it means is that if somebody is unwell and the first week they will check to see, and it's always the case that the payment calculation will start from the fourth day or day 4. So if you are working 5 days a week, the first week being 5 days, your day, and because the provision allows for the calculation from day 4, you will have to look at the 1 week and the 4th day. So in terms of calculation, you can then say that if you have Monday to Friday, the calculation for that week will be 5 out of the 4th day, out of 4. You multiply by the weekly rate. So the weekly rate, we are told from the nugget, is £109 some pence. And you multiply by 5, you divide by 4, and that will give you how much ought to be for that week in that order. So if it's more than 1 week, then times the number of weeks and on and on. So that is how it works. Can the employer choose not to pay? It's a statutory duty, and therefore the employer cannot choose to say no.
Well, let me find out the rate that's giving, as we find on the screen, is £109.40, 40 pence. Sorry, I thought I was talking about dollars. Does it depend on how much you are paid? For instance, if somebody is on £35,000 per annum and the person is off sick, are we calculating the rate of sick pay based on how much the person earns in total end of the year, or this £109 is standard, and no matter what grade you are on?
So this is the statutory duty, and the rate is £109.40 a week.
Okay.
So if you want to know how much the person will be paid, and remember, it's sick pay. So we don't expect the person to say that, how much will I get the next 6 months, unless the person knows that they're going to be sick for the next 6 months. In this case, the conclusion will be different. But suffice to say that somebody is off sick for a particular week, then we use this rate. and the more weeks there are in that order, it's multiplied.
Okay. Now, if it is not paid, what should an employee do?
Because it's a statutory right, the employee has the right to request that payment from the employer. An employer has a duty to pay the employee. Otherwise, it will be withholding of pay, which also has statutory implications for the employer.
So, for how long can an employer pay an employee sick pay? For instance, is a long-term sick situation, and you've been away for more than 6 months. Are there any implications when you go off sick for a long time?
So usually, if we have long-term sick. So if it gets to that point, the employer has to trigger what we call occupational health assessment to see whether the person is fit to carry out the job. Because if you are going to be perpetually sick, then it appears that somebody has to carry on the employer has to make plans for replacement. In this case, they have to carry out occupational health assessment. The employer will get an occupational, most employers have occupational health assessors. So they will do the assessment to see how long the employee is expected to return and the impact of this, whether it's going to be short-term or long-term. If it's going to be long-term, then there are instances where for health reasons, the person may have to be not made redundant per se, but if you are going to be sick, and if your sickness is going to impede your work, then it appears that you have to be given early retirement on the basis of sickness. Those aspects are there. But for today's conversation, we are looking at everyday request for absence based on sickness, and the employer saying yes or no in terms of the pay, and what the employee also do when an employer is being penchant on the fact that they don't have to pay. Most employers know that it is their duty, so they know that they have to pay. Some may not necessarily know, and therefore this conversation is very important again for employees to also be aware that much as you have a duty, if it's going to be overly long term, then there is implication.
Somebody just texted me, and we're looking at what we're putting on the screen and the rest of it, and now it's asking, I employ people based on what jobs I have. I'm a handy person, so I'm thinking of it as a 0-hour contract and the rest of it. Do they also enjoy this kind of right?
So it depends on the status of that person. We have self-employed and we have employees or employed. So if per your arrangement, it appears that they are self-employed, for example, you are a handy person, as and when you get them, you subcontract them, then it appears that the arrangement will be self-employment. Self-employed people or persons do not enjoy statutory sick pay, but they are independent.
Okay. Well, they can give themselves sick pay and sick leave. So
That is why if they are not able to, there's what we call unfettered substitution. They can ask somebody to come and do the job as long as the job is done and the client is happy. But if the client insists that they have to be done by, the job has to be done by this individual, then it takes into a different conversation.
Well, folks, if you just joined us, we're looking at our nugget, which is statutory sick pay. And it's the legal minimum payment staff should get when they are off sick. And Lawyer Charles Osman has explained the various eligibility requirements and also how much the law says that from the 6th of April 2023 should be paid. And it is £109.40. The previous rate was £99.35 per week. It is usually payable from day 4 of sick absence, as Lawyer has explained. During the COVID pandemic, statutory sick pay was payable during the periods of self-isolation, provided employee met certain eligibility criteria. However, these laws have now been removed. So when you work for an organization and you do not feel too well, you have to let them know. I think a doctor will have to sign you off and you could be paid the minimum wage. That is £109.40. And with that, we're coming to our discussion. If you have any comments, any question, you can put them in the segment below. Like the page, share the link, and get people to also come join us. Good afternoon. Ademununkum says, good afternoon, everyone. Thank you very much for joining us. We're moving on, and let's give some shout outs to some people who have joined us on the line. Sandra Fraser, good afternoon, boss. Good afternoon, ma'am. How are you doing? Sandra, thank you very much for the plenty information you put on. You've provided us with all the details about the BWF solicitors, where you get transportation from, the address, the telephone numbers, and the rest of it. Now, if you join us, please let us feel your presence. Put a comment in the section below, either on Facebook or YouTube, or you can text us 0739920848, or on WhatsApp 07950422780. Now, last man, let's get back to our discussion for today. I'm talking about British children who would need passports. Somebody asked me this basic question, and I decided to leave it and ask you, why does any individual of any country need a passport?
Right. Passport is a travel document.
Okay.
It is also used for identification or to prove one's identity.
Okay.
So we say that it serves the purpose of proof of ID and also proof of, it's also a travel document.
Okay.
Why is it a travel document? Because you need to be able to prove your identity. If you are traveling or you are crossing a border, we have to know who you are. And therefore, passports are very important official document to tell who you are and to also allow you passage into other territories.
Who owns a passport?
Passport is issued by a country, a sovereign state, for its members.
Right. So, can I, as a citizen of any country, decide that I don't need a passport? Or, looking at it from the other angle, can any particular state say to an individual that I won't give you?
It's a right.
Okay.
So, and at the same time, it's a choice. So the government cannot force it on anybody, but the government cannot withhold it from anybody. And therefore, once you feel that you need it, you request by way of procedural process, and you are issued with one. Once it expires, you request for it to be renewed, following the processes involved.
Right. Okay. Now, I having taken these basic things out of the way, a British citizen demands that, or may demand that he or she needs a passport. Can it be issued outside of the UK to a British citizen?
It is possible, because countries everywhere in the world have their reps everywhere in the world.
Okay.
And therefore, if the service is to be provided elsewhere and there is a rep at that particular location, then the rep of that nation will step in to have it processed and issued. So yes, it can be issued elsewhere other than UK.
Okay. Now, still looking at the basics, if I have a child and the child is less than 18, is it the responsibility of the parent to apply for a passport for that young person?
Yes. And on that basis, the parent will have to consent to that child receiving a passport.
Okay.
And remember, as part of the parental responsibility, they have to make decisions for the child. And we are looking at important decisions, which include acquisition of passport. And therefore, the parents will have to agree to the child being issued with a passport. Once the child is of age, then they make their own decision.
Okay. Now, I then come to the realm of now. You said that the passport could be issued outside of the UK. Can I, as a parent living in the UK, apply for a British passport for my child that one was born outside of the UK and living in another country, and uh, maybe I or consent that they give that person a passport? Is it possible?
It is possible, provided the child applicant meets the rules under which this application is being made.
Well, I knew that the criteria and eligibility is coming because some of these things, obviously, it can be issued to anybody. So, if you don't mind, take us through the various steps. What are the eligibility criteria here? Who can do that? Who cannot?
Thank you very much. So we have our starting point, and just to, by way of context, I think we've set a context already, but there are a lot of people living in the UK who may require passport for their children, and the child is living abroad. First off, the child was born abroad and is still living abroad. If the parent make that decision for the child to acquire passport, they have to apply. But the key thing is, it is the child making the application. So the application will be done overseas. Because it's a British passport and the child lives overseas, the application will be done overseas in the country where the child lives. But would the process complete and end, or start and end in that country? What normally happens is that the process will start, all your evidence will be sent to the UK for processing. And once it is processed, you go through the process, the stages that will be taking you through today. And once they are satisfied that this child has met the requirement, the application will be approved and the passport issued for the child. Once the passport is issued for the child has acquired his or her British passport. So by the time they even enter the UK, they have their passport to travel with. But it's important that for this afternoon's conversation, we understand the steps and the statutory criteria for anybody who wishes to embark on this journey. So I will take you to the British Nationality Act 1981. If we look at Section 2, subsection 1, subsection A, it will tell you that a child born overseas and parents are British citizens, otherwise than by descent, then that child or those children take after their parent or that parent who is a British citizen at the time of the child's birth. And that parent's citizenship was not acquired by descent. Descent simply means that you take after a generation, so through a generation. And we can look at instances so that it becomes clear when we say by descent.
Okay, so if we talk about by descent, does it mean that, for instance, I am the parent and I acquired my British citizenship through my parents? Can I pass it on to this particular child that we're considering?
So you can see that.
Would that be by descent?
So yes, then that you will not meet the other limb of the test. It says otherwise than by descent. So if that parent acquired it by descent, then the offspring cannot acquire it again from them.
Let me see if I can get this a bit clearer. My parents were British, and I acquired my British citizenship from my parents that were British. If I have a child. Would the child have acquired their British citizenship by descent because I acquired it from my parents? Is that what we are
So there
describing?
becomes a chain, more or less.
Okay.
And so imagine if this chain continued to exist, then it would be so easy for a lot of people to acquire citizenship. Just like USS. It would have been easier. You just need one person to establish presence, and the rest follows. So we have people who acquire citizenship by registration, children, and those that acquire citizenship by naturalization, which is adults. So if I acquired my citizenship by registration, then it is not by descent. More or less.
So you can depend on yourself.
My own right.
Okay.
So we have children who also acquire citizenship in their own right. So a child who has, for example, lived in the UK for 10 years and has been registered, then that is in their own right.
Okay.
So that is how it works.
So the child that is registered to acquire British citizenship does not necessarily have to have parents that are British. Or the child, having lived in the UK for 12 years, even though born to British parents, can register themselves and acquire their nationality on their own. So they don't depend on having it by descent.
So, I mean, to be fair, sometimes it depends on the circumstance. I don't see why any parent would say, wait till you are 10 years so that you do it yourself or you acquire it by yourself, whilst it's easier to
To
do
do
it through for them. Yeah, so let's take example of this child who is going to acquire, this child lives abroad and the parent is applying for the child, but the parents has established that they did not acquire their citizenship through their grandparents or what have you, the ancestry route. Once they have done that, so this child comes in with their British passport, because they've acquired it under Section 2. If the child comes in and establishes him or herself, also already has a child, but this child will have a child in the UK. If the child has a child elsewhere, let's say abroad, it's also going to go through overseas passport application process, then the question will be that this parent of this new child, so to speak, so now it becomes a third generational point. So the child in question, which is now a parent, got theirs through their parent under Section 2. Can they also pass it to another parent under Section 2? Section 2 says you don't have to have it otherwise than you should have had it. You should have had yours otherwise than by descent. So if you had it by descent, then you cannot transfer it to another descendant, so to speak.
Okay.
It's a technical aspect.
Very technical and quite confusing,
yes,
really.
Technical aspect of the process. But all we are saying is that once you have it, you cannot continue to transfer it.
So can I break the chain this way? I have acquired it by descent, but I don't want that Section 2 to affect my child. So I wait till the child gets to the age of between 10 and 12, and I can register the child so the child stands on their own two legs.
That means the child has acquired citizenship under Section 1.3.
Okay.
Yes, so in that Section 1.3 and also aspect of Section 1.4. So in this case, they are acquiring it in their own right. They have lived in the UK for 10 years and they are making their application. There's also another way, the 1.3 aspect, where at the time the child was born, the father or the parent didn't have indefinite. The parent has now acquired settled status under EU or has got indefinite leave to remain under Appendix FM provisions. Then you can register the child to become a British citizen, because 1.3 says that if the child was born and at the time the child was born, the parent did not have indefinite, and later the parents have acquired indefinite, but the child is still under 18 years, then they can register the child. So if a child goes through that process to acquire citizenship, then that is not descent.
Okay. Well, I was going to ask that question, but I think you took the wind out of my sail. I'd still ask it, maybe to clarify it better for somebody who might find himself or herself in this situation. I have children that are British. We have gotten them to register. I live with them in the UK. For some reason, I've had another child who is outside of the UK. The child was born when I did not have my indefinite leave to remain and subsequent naturalization to get a British passport. Now, when I get my British passport, can I use that status to cover the child that was born when I had not acquired this present status?
The rules say that when the child was born, the parent had citizenship.
Right.
So if you're not a citizen at the time the child was born, then you cannot pass it.
So such a child cannot become British?
So the child can become British, but not by birth per se, because at the time they were born, the parents were foreigners.
Okay.
Yeah, the parents were foreigners.
So in that case, that particular child that we're describing in this scenario cannot apply for a British passport outside of the UK.
Then in this case, it will not apply. By the time they were born, the parent or both of them did not have
Okay.
citizenship. So the child will come in, go through the process to be registered, or to naturalize.
And to naturalize. Okay. Now, then let's see how it is done. I think it would benefit people who really are in this situation. Now, we're going to do that step-by-step process where we'll get Lawyer Charles Asma to help us look at that. If you just joined us, you live on BWTV, and the program is The Community and the Law, and we're bringing you the discussion on how to apply for a British passport for a British child that is outside of the UK and living abroad, I should say. Remember, BWF Solicitors is our proud sponsor this afternoon. Tili Duma, Nana Jimai, and all the other beds, people who are supposed to join us, Wimpini Adam, Ezekiel Johnson, and all of you. Those who are regular members of the class, I am expecting to see you, and I'm expecting to read your comments as well. Now, Lawyer Asma, how do we do this?
Okay, so let's take our simulated individual parent.
Right.
So this simulated individual parent is called Simo.
Okay.
Simo is a British citizen.
Right.
And Simo acquired British citizenship by naturalization, which is Section 6 of the British Nationality Act. So lived in the UK, became settled or had indefinite, and went through naturalization and was issued with Section 6 certificate, Section 6(1) certificate of citizenship. Simo lives in the UK, but travels or has original country, of course, has a child elsewhere in the world. Is Simo's child a British citizen or a citizen of that country where this baby Simo was born? So we have to look at the rules. One, baby Simo was born abroad. So baby Simo will not fall under Section 1, because Section 1 says a child born in the UK. So it will not fall under 1. We'll go to 2. 2 says a child born outside the UK. So in this case, 2 will apply to baby Simo. We also check to see whether baby Simo's father did not acquire his, the parent did not acquire his or her citizenship through the ancestry route. And we conclude that Simo, the father of this child, acquired through naturalization. So it appears that it is not through ancestry route. Now, having established that this applies, so we have ticked the box for Section 2. What do we do? Are we going to apply it by traveling? Will Simo travel to the country where the baby is to apply? Not necessarily.
Okay.
Simo can stay in the UK and apply. Will Simo apply for this passport online? No, because online passports are only for children who are applying for passport either the first time or subsequently, but they are not doing it under Section 2. So that is one thing. If you apply online, they will come back to tell you that this application is not valid or the child is abroad.
Okay.
In this case, we have to do it on paper. And the paper is called Overseas Passport Application, OVS. OVS form is available online. You print, complete, and add your documents. You then post it to them. The question is, what other document do I have to support or put together to support this application? You have to prove that you are the father. You have to prove that at the time you gave birth to your child, you were a British citizen. We also have to check whether the child was actually conceived and delivered, quote unquote, for you.
Now, if you say the child was conceived for you, how are you going to prove that?
So they will ask you to provide evidence of the child, evidence of the child's mother being pregnant. Sometimes they will ask, yes. So there should be photos.
It's a bit ridiculous.
It is, but it's part of the processes they follow. So they can ask for that. They can even ask for the scan, the hospital scan. So we are talking about all the hospital documentation. And more often, the hospital documentations may state the name of the father of the child at a point. So that is also a way to link you to the child. So you can see that the threshold for overseas passport applications for children is quite higher compared to in-country. For in-country, it's straightforward online. So you provide all this. You also have to provide a child's birth certificate. You also have to provide even evidence that you travel to the country where the child is, to the point that it is possible that you are the father.
Okay.
Because if you don't travel to that country, how did you become the father of this child? Yes. How did the conception take place per your involvement in the first instance? So they ask for all these things just to see that people, they are dealing with the right applications.
Okay.
So to speak.
Okay.
And so passport picture of the child will also have to be provided within the last 3 months. So current passport picture. If the child is abroad, how will the passport picture be available in the UK for it to be used? It doesn't mean that if the child is abroad, they cannot process the document and post it to the UK. They can. But it's always easier if you have a rep in the UK facilitating it for you. That is why we say that if you are doing it in the UK, you get all the document and you send it across to the passport office. Then you deal with all the questions. It can take a long time because they can be back and forth. But it's a matter of making sure that anytime they come back for anything, you follow it through and you respond. But as we progress with the conversation, we will add some more.
Oh my days. And I don't think it's anything that comes easy. We're looking at paper application, as the lawyer has said. What documents do we need to provide? And when it is that we have provided that, who completes them? Where is it sent to? And some of the other technicalities that we'll be looking at. You're live on BWTV, and we're bringing you the community and the law, brought to you by BWF Solicitors. Now, when you want to make any application concerning your status here in the UK, talk to BWF Solicitors, 0208 493 7340 or 077 127 61884. BWF Solicitors, with over 30 years of experience behind them, They are the trusted partners when it comes to the law. Trust them, go to them. Let's take their message. We'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Well, thank you very much for your time and thank you for staying with us. BWF Solicitors, thank you very much. And we believe that we will get the opportunity to enjoy your services as long as we trust you. The trusted partners when it comes to the law is BWF Solicitors. Well, we're going to continue the discussion and we're looking at how to apply for a British passport for your child born abroad and living abroad. Remember the criteria: born abroad, living abroad. And you who is making the application, you should not have acquired your British citizenship by descent. By descent means that you acquired it from your parents and you are passing it on to your child. That is not an eligible criteria. Lawyer Tasosma is here, and let's go back to him to help us with the discussion. If you want to text us, the text number is 07399208468, or you can call us on that number as well, 07399208468. If you are sending a WhatsApp message, either voice note or a text on WhatsApp, 07950422780, as is at the bottom of your screen as we speak now. Lasma, somebody's asked this very interesting question. I know you've picked it up, but I will still pose it. If I have a stepchild that is abroad, now the child came into my life when I had my British citizenship, was born prior to my relationship with the mother. But when I got involved with the child, I was a British citizen. Can that child qualify for this?
So the rules say that a child born abroad to a parent who is British and that parent acquired citizenship in other means, otherwise than by descent. So, question is this child born abroad? Yes, from the story we have heard from our friend.
Mm-hmm.
Is this child born to a British parent? It appears no, because he says that he's not a biological father.
So the child cannot
The test
qualify.
is not met.
Okay, right. Coming back to your discussion, you mentioned that as a paper application, you can't do it online, even though you can download the form online. Who does the application? Can I, for instance, as a parent living in the UK, have a child born outside of the UK and living outside the UK? Who does the application? Do I have to do it whilst I'm in the UK? Or I have to go over to that country and submit the application there?
Thank you. So anybody can do the application from anywhere. If you have a rep in the UK, it makes it easier because the application forms and supporting documents must be posted to the passport office for overseas applications in the UK.
Okay.
So if you are doing it abroad, you still have to post the document to the UK. What it means is that if you have a rep in the UK, it makes it easier. You don't have to post from there, and the rep can deal with them directly. However, once everything is over, you will be notified, you, the main person in the home country of the child. Just to answer that question so that I don't take the wind off from yourself.
Well, it's okay to push it.
Yeah.
So, if for instance, this child lives in Nigeria, for instance, and has a Nigerian passport because was born there, but I want to confer British nationality on that child, can I get that child to travel to the UK and I make the application here?
No, because the child will not travel to the UK as a British citizen with Nigerian passport. So you have a choice to let the child come, then you do it here, or you can let the child acquire the passport. Because presumption is that the child wants to have British passport because they are British citizens. In that case, you can do it if you are doing it for your child. Go through the process in Nigeria, or get a lawyer in Nigeria if they understand the rules, the British rules. For every country's rules differ. Otherwise, get a lawyer in the UK to do it for you, and it's easier.
Okay. How quickly is this done? Are there delays in there? I'm asking because most of our applications that will go to the Home Office has a minimum period of what? 6 months?
6 months, now they say 9 months.
Oh wow. So how quickly can I get a thing like this done?
All right, so this is not with the Home Office. This is with Passport Office, His Majesty's Passport Office. And therefore, we are dealing with the Passport Office. However, it's also a process, and this is not an in-country passport application. So it will go to the overseas unit. It will usually go to Belfast or Durham for consideration. And if everything is straightforward and they don't need to come back for anything, then it should be within 6 months. But if they have to come for some confirmation or clarification, then it can take as long as 1 year.
Previously, you have mentioned to us in our discussions, and that's knowledge I'm trying to rely on and depend on, that a young person or a child takes his or her nationality from the father,
The parent.
or not necessarily a father, but a parent.
The parent.
Okay. Well, let me put it this way. If I am a man and I have a child outside, I am not a British national, but my partner or my wife is a British national. Can my wife make such an application for that child outside?
It is not the person being your wife that matters. What matters is that the person is the mother of the child.
Okay.
Therefore, she's a parent of that child.
So if the parent is a British national, domiciled in Ghana, for instance, and I am the father, can the mother apply for that passport for that young person in Ghana?
Yes, the mother can. If you are doing it, it won't be in your name because you don't qualify as the father under the rules. The parent in this question, the mother. Just that the mother has traveled or is on holiday, happens to be overseas, and wants to start the process. Yeah, they can start the process from there, or they can equally ask you to start the process from here. At a point, they will have to confirm by consenting to the application process. So they have to sign. And the signing, because this is paper, you can scan it, send it to the person to sign, they scan it and send it back to us, having signed the signature. We have the paper, then we use it.
Somebody's just sent me a text and is asking, My parents did not do the application for me, but I am 18 now and I'm in Ghana. Can I apply indicating that my parents are British?
Is this person who is 18 a child?
Well, technically, no.
So they can't.
But can they take their nationality from their father
We say
or
a
their mother?
child.
Okay,
Within the rules, a child is somebody under 18.
under 18. Okay. So obviously, your answer will be no. So you can take advantage of that. Um, that application, apart from the eligibility criteria, can it be refused?
Well, there are instances where if they feel that the child doesn't qualify, they will grant and even cancel. That's what we did. We did for 3 kids. They issued the first one, and we told them that, oh, we applied for 3. If only giving us 1. And they wrote back and said that, oh, even the one we issued is by mistake.
Oh, days.
So we had to go through the process again. But eventually, thank God, we had all of them issued. And the children are getting ready because the mother doesn't have, the mother doesn't have leave to enter herself. She has to get the leave, then she can come in. Children have to be catered for once they come in. Yeah.
Right. As I said, the discussion is about how to successfully apply for a British passport for your child born abroad and living abroad. Lawyer Charles Asma is taking us through the discussion, and he's telling us what to do, what not to do, how to get it done, and how to really make sure that you are okay with it. My question is, can I retain? Okay, we will be taking some of the comments there. I see somebody say, "Hey, Kweku, how are you?" I am fine. I'm doing very well. All that. Lawyer Asma, now tell us in sum, who can get this done? Who cannot get this done? And how can we successfully do that? Maybe before we take any comments.
Right.
And probably any other information that needs to be had, then you can add that for us.
Sure. So anybody who qualifies can do it. Usually the parent will put in the application for the child. The application form is online, so you print, complete, and have them signed. If the child is not at the age where they have to sign, they are about 13, 14 years, then they will be able to sign themselves. Otherwise, the parent can sign for them. There will be a session. So it's a matter of meticulously going through the application form and making sure that you have factually addressed every question correctly. And once you've done that, you sign as the parent who is making the application for this child. The next stage is for the documents required. The father or the mother making the application for the child will have to show that they are British citizens. So they will have to provide their naturalization certificate. They have to show that what it means is, so Brakaku, the reason why they ask for evidence of your naturalization is this.
Okay.
We say that at the time the child was born, the parent was British. How do we deduce that? We take the child's birth certificate, we take the parent's naturalization certificate, then we'll compare the date.
Okay.
If the birth certificate came after the naturalization certificate, then at the time the birth certificate was issued, the parent was already British.
Okay.
So imagine there is no evidence of your
Naturalization.
citizenship. How do we tell that you meet the rules as a child whose father or mother was British? We keep using father because fathers predominantly go through such applications, but it can also be mother. So I'm going to say parent henceforth. So once the parent has qualified, yes, so naturalization certificate is very important. Then We're also looking at the child's birth certificate linking the father to themselves. We're also looking at the mother. If the father is the one doing it, the mother who gave birth to the child will also come in. We want to know when the child was conceived. We want to know not how, but the fact that the child has been conceived, so the pregnancy moment and also the delivery moment. And even, so we have post and prenatal hospital records. Those are very important. That's one. If the child is, let's say, 17 years, that means they've lived for 17 years. So they should have evidence that the father is supposedly their father and his father plays a role. Not that the law says the father should play a role or the parent should play a role. But if this is your child, then we want to see what we call family progressive photos.
Okay.
Because if this is your child, the child is 17, you have no picture with the child, then it's not legal doubt, but common sense doubt. That, especially where the person is saying that you always go there to visit them. Right. So photos are very important. And also if the child has, as we said, 17 years or at least 5 years, 4 years, whatever it is, there should be photos. They call it progressive photos.
Are they statutory demands, or it's a common sense strategy that lawyers of your ilk use?
Right. Well, the only statutory requirement is that the parent is a British and the child was born after the parent had become British. But if that is left open, then the law could be subject to abuse.
Okay.
And therefore, they try to put in place processes to ensure safeguards. Safeguards include making sure that they're issuing a passport to the right person.
Okay.
Not anybody at all who claims to be a child of this British parent. So if indeed this is your mother, at the time of your birth, was your mother married to your father? That is another argument. And the reason is that we know that if at the time of your birth, your mother is married to your father, marriage, then your father will be the father who is in the marriage, not your biological father. So if your biological father is the British citizen and you want to take advantage of Section 2, but your legal father is not a British citizen, then you cannot be a child of a British parent.
And in that case, then, if the parents would want you to acquire your citizenship, then you have to be in the country, register if you do qualify, and use the other route.
Yes, they use other options to get. So we are looking at, because somebody can say that, right, I'm married, and for whatever reason, I had a child with this man. This man is British. My child is British because your law says X, Y, Z. Then the question would be, at the time of your birth, was your mother married to another man? If your mother was married to another man, then your father is that man, not
your
the biological one. And therefore, you will not be able to take advantage of the rights within the rules.
Okay. 073-9920-8468 or 07950422780. These are the means through which you can join us on the program by text or voice. Or you can send your comment down below. The page, Facebook is BWF Solicitors and BWTV, and also on YouTube, BWF Solicitors, BWTV. How to successfully apply for a British passport for a child born abroad and living abroad. In the meantime, I told you that I was going to actually ask you to do some calculation. So I'll go to the nugget again and we'll look at what it is saying there. Statutory sick pay is what we talked about earlier on. It is the legal minimum payment staff should get when they are off sick. That is, incapable of work due to sickness or injury if they meet the eligibility requirement. For the tax year beginning April 6, 2023, the rate is £109.40. The previous rate was £99.35 per week. It is usually payable from day 4 of a sick absence. During the COVID pandemic, statutory sick pay was payable during periods of self-isolation provided the employee met certain eligibility criteria. However, these laws have now been removed. So we'll be doing some calculations. So get ready for that. I wouldn't be showing you the question now, but we're doing some calculations. So get your calculators ready. Start thinking of these things. And then back to our discussion, we're looking at what is required to be done so you can successfully apply for a passport for a British person, so to speak, that lives outside of the UK and born outside of the UK to a British parent. Now, Lawyer Charles Asma is telling us that you don't need to have passed on the citizenship by descent. The person would have to acquire it either by naturalization or through their own rights to be able to do that. BWF Solicitors, thank you. BWF Solicitors, we're so grateful because every now and then you give us the opportunity to enjoy all the updates that come when it comes to immigration matters. If we making any application for stay, any appeal, you help us lodge all those things and you successfully help us go through that. Any other thing regarding the law, marriage, divorce, and all the other things, BWF Solicitors is our trusted partner. Let's say thank you to them.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Welcome back. Thank you very much. Your participation is well appreciated, and want to also say thank you to BWF Solicitors. So your questions, your contributions are invited now either on Facebook or YouTube. You can text 07399208468 or send WhatsApp on 07950 422-780. 07950-422-780. Now, Lawyer Asma, anyway, sorry about that. My husband passed recently, and I have children who are his and living outside of the UK. Can I, as his next of kin, apply for them to have passports abroad? My partner or my husband was a British national before he passed.
So there have been similar instances. So if this deceased father can be seen to be the father of the children, that's one. And two, if he was a British citizen before the children were born, then yes. He is not available, around, but the mother can put in the application for the children. So that's possible.
So this, well, I'm not talking morally here, but this mother knowing that the husband had children with another person, but would want to make sure that they confer the father's citizenship when he was alive onto them. Can she do
Had
that?
children with another person.
Yes.
Oh, so these children are not this mother's
Yeah,
children.
but they were the father's,
All
the,
right.
the
So
past or the deceased husband's
good
children.
Samaritan of a sort.
Yeah, well, that's why I said
Yes, so
I'm not talking
so-
morality here, but I'm looking at
So the application should be put in by the mother because she has no locus in this conversation in terms
Okay.
of this application.
Okay.
So the mother of the children will, but the father is not there to do that. So the mother of the children will have to put in the application.
Okay. Why am I having difficult conversations this afternoon?
But as we said earlier, we also want to see whether the woman was married to another man.
Okay, because
also
then that changes the whole scenario because legally those children are the husband's children.
It's also important.
Oh, okay. All right. You see, that's why it's good to talk to a very smart lawyer. we may not have thought of this one. Thank you very much, Lawyer Charles Osman. This one is saying that I have been abused by my partner, and the social work department in my borough has taken me away from there. Do I still have to pay rent to where they have taken me to?
Right. So whoever took you to where you are living knew that they are taking responsibility, including accommodation. So I'm not sure whether they've asked you to pay accommodation, pay for the accommodation. If they haven't asked you to pay for it, then you don't have to worry about that. If they have asked you to pay for it, you can tell them you can't afford.
So okay, I'm thinking of a scenario like this. What if they say that we're paying half of it for you because where you were living, probably you were paying half of it, and they've taken you to a place, so now they're paying what you were paying for you, then the other half you have to cough it out. Is that what should happen?
I'm not sure if that is what is happening, but if that is what is happening, then they are not doing, then she's not experiencing any new thing.
Okay.
Because she was paying part anyway, and she's been relocated, so life continues. What is not happening is she's not subjected to abuse that she was being subjected to, so she's got her freedom and liberty back. But in terms of meeting her essential living needs, if they've done the income assessment and they think or they have concluded that she has other income, so she has to partly contribute to the cost of accommodation, that's a fair request.
Oh, okay. But then the person can go back and say, well, you took me away, so you have to cater for me.
But it's a fair request, and therefore, if there's means for her to do that, I don't see why any rational being will say, I won't pay for to be sheltered.
Okay.
What it means is that if she says no while she can, then it's possible that they will make another alternative arrangement, another one, so that she will be moved from here to more cheaper place, which may not be what she wants.
What you want? Okay. All right. Can somebody refuse accommodation that's given by a local authority?
I know people tend to say, I don't like this, but if the place is not habitable, then it's about health and safety. So you can say no. Of course, you point it out to them, and they will know that this is not habitable. If the place is already molded, if the place is moldy, if the place is full of rodents and so on and so forth. Remember some time ago, we had conversation that the landlord is supposed to do X, Y, Z to make the place habitable, protect the property. So if the property is not habitable, I don't see why the council, especially if there are children involved, will take this person to that property. But people will say no because they want maybe more spacious place and more luxurious place. And get to a point, it's not about luxury, but it's about what you need. So necessity. If you are alone and you are given one room, you can't say I need another for my visitors. If you and your child and you are given two, then you can't say we need another one. So those are the dynamics.
Okay.
All right.
073-990-8468, Your text messages or WhatsApp messages are welcome now, and we'll take them. We can pick up some of the comments on the screen now if any is ready. My one question is this: can I retain my right if my spouse refuses to respond to my divorce application after 3 years of marriage and is broken down irretrievably? No.
If after 3 years of starting the divorce proceedings, the respondent has not responded, you don't have to give up, but you made the application. So it might be that the respondent cannot be traced. So you have to then request to do what we call process server service or personal service. So the court will give you permission to serve the papers personally. So you seek the service of an independent process server. They will take the notice of proceedings and personally go and deliver and make a note. And the note becomes evidence of service. You then request the court that there's evidence that the person has been served. The conclusion possibly is that he's deliberate not to respond. And so we should treat this as deemed service, and the court may grant the application. Once that is done, the process will continue. But if the process is not over, there's proceedings going on. If you have, remember, for retention of right, you have to show that there has been a supervening factor. And your supervening factor in this case would be the divorce certificate. So if the divorce has not concluded, you only have the proceedings document. Then what do you have to show? If your visa is expiring and you have to apply, then you can use the papers to show that proceedings have started. My partner is not willing to support or to sponsor me, and therefore I can't provide anything. But this is the evidence I have, and they will make a decision based on that.
Right. This one is asking if I came here on the on a certificate of sponsorship, on a COS. That's what the person is saying. My partner is the one holding the license, and I am allowed to work any number of hours. Can I apply for any benefits whilst I am allowed to work any number of hours?
The person should check their card. They will see no recourse to public fund. That means they are not entitled to benefit.
Okay. But in that situation, can any application be made for it to be removed?
No. But remember, this is a specific application to come and work.
Okay.
So why are you not working?
Okay.
Your wife, even if you are not working as a dependent, the main person is working, whom you claim is your partner. So even if you are not earning, your partner is earning, and the rules allow for 20,000 and above. So within the family, you have 20,000 before tax. Give and take, 12,570 is tax-free. You take that bit, 8,000, 20% to a 16,006 divided by 12, about 130, 150 a month. So give and take, whatever you take home will be about 1,006, 1,007. So if you are taking 1,007 as a family, and it's just two of you, your rent, your earnings, and your outgoings, you put together, you may not be destitute.
What if I am?
Well, then, but yeah, so if you are destitute, do you have recourse to public fund? Because not everybody who is
There's a
destitute.
situation on my card. It says that I have no recourse to public funds.
So if there are
But
children
I
involved,
don't meet the minimum criteria to
if there are
survive.
children involved, then they will step in in the interest of the children, but not to give you money to survive. So it might be that they will look at how they can ensure that welfare of the child is maintained or sustained. But it's not a case that you are going to be supported within the welfare system because you don't qualify and you cannot apply to have it removed.
Okay. Lawyer, I have a
And mind you, this
okay.
is not an Appendix FM application.
Okay.
It's
Yeah.
not a
this-
family migration application. It's skilled worker. A skilled worker.
So obviously, there's job for you.
Obviously,
There's job for you to do, and you have to
You
earn some
and
money.
your partner should be able to work and earn and live.
Lawyer, I have a construction company. How can I get people to come and work for me from Ghana?
You have to apply for license as a sponsored or a sponsor employer. Once you have your license, you can recruit. Well, you put your advert and have people to apply for the jobs that you want them to come and do for you. Take them through the recruitment process, and the successful ones, you give them certificate of sponsorship for them to apply to come and work for you.
Okay. Now let's pick one of the comments. This one says that, lawyer, a British citizen has impregnated a woman, but unfortunately he died before the child was born. Can the mother apply for the child to be a British citizen?
That's a test case scenario. So,
Brains are working.
I mean, so technically, on the birth certificate, this man's name will appear. That's one. And there will be evidence to show that this is the father of the child.
Okay.
If they want to know where the child, the father is, there will be death certificate to show that. There was one application I did that was for a child applying for registration to become a British citizen in his own right, 10 years, born and lived in the UK. Father was also living in the UK, so father had leave to remain and the child also had leave to remain, but father passed on. By the time of the application process, we have to show death certificate of the father. The father, where is the father? So we had to show that. I suppose in this case, even if it goes to court, it becomes an argument to show that indeed this was the father who, or this was the man who fathered this child. Unfortunately, there will be nobody to help with the DNA process because the man is not there. But I suppose that's why I said it's a test case. It becomes a legal argument. I don't think that there are not many of these instances. There are instances where the child is born and the father dies. There's one we did. The father was British, traveled to the country where the children were. The father was murdered, and unfortunately, but then the mother put in application to have the children issued with British passports on the basis of the father. So the father was there before that. So we're able to show evidence of the father in the life of this child. You know, in this case, if the child, so this is in the UK, it's not like abroad. So this is in the UK. In this case, we have the birth certificate showing the father. We have the father's naturalization certificate. You submit, then you see what inferences they will draw. That will inform your response.
Okay.
And that's why I'm saying that it's a test case, because these things don't often happen.
Well, somebody is asking, were they married? Well, I don't know whether they were married, but if they were not married, would that change the scenario?
The rules say that a child born to a British parent,
Not a
and
British
if
wife
British
or
parent,
husband.
British parent. So
Okay.
in this case, the father was British at the time of the child's birth. But we know that at the time of the child's birth, the father had ceased to be British, but the father was dead. If you are dead, are you a citizen?
No.
You are a dead person. So at the time the child was born, the father was not a British citizen, so to speak. So it's a technical argument. And if we stretch that argument, then we can conclude that the rules say at the time the child was born, the parent must be British or settled. At the time the child was born, what citizenship was the father? Then somebody will argue that the father was dead actually,
At the
and
time of the birth
therefore
of a child,
the
yeah.
child was born to a no father. Technically.
Okay.
And so you can see that within the rules, this contemplation had not come up and or wasn't, so the drafted of the law did not contemplate this possibility.
Okay.
And therefore there's no part which says that if at the time the child was conceived, the parent was British. It says at the time the child was born, the parent was British. Was this parent British at the time the child was born? My argument will be technically, but for the death, the father,
The father would have been a British citizen.
and therefore the demise of the father should not be visited on, or the dangers associated with the demise of the father should not be visited on the child. And for welfare purposes, for the benefit of the doubt, let's give it to the child. If we are choosing between who should have this favor, let it be given to the child. But they also argue that it's not about who the favor should be given to, it's about the rules. And therefore, within the rules, does it say that at the time the child was born, father, mother, British? And the answer would be yes. Does it say that at the time the child was conceived? No, it doesn't say that. Does it say that at the time the child was born, if the father who conceived the child was dead? The laws don't say that. It becomes technical.
Well, when it becomes technical, you need a strategy. And definitely, if you have somebody who can properly strategize for you, it's BWF Solicitors, 214-218 Tottenham High Road, Seven Sisters, North London. 0208 493 7340 is their telephone number. Lawyer, there's this question that came to mind when you were explaining the previous one. If I know that somebody is conceived for me and the person lives outside of the UK, and 6 months into the pregnancy, can I start the process of making sure that the child is given a British passport or citizenship at the time that it would be born?
So the rules say at the time the child was born. How certain are you that this child will be born? That's one point. Then, if you also know that you are not going to survive the birth of your child, then you can do a will and say that I will my
Citizenship.
right to my child within the rules. It becomes a legal argument for the court to battle with.
That'll be another test case, isn't
Exactly.
it? Okay.
But we don't contemplate these things.
So in effect, I can will my status.
I'm not saying you can. What I'm saying that even if somebody did that because they knew they were going to die and wanted to grant the right that a child would have within the rules to them before, let's say they want to pass on the inheritance to the child before they died.
Okay.
And we know that the will is the will of the dead person. So we effect the will of the dead person.
Can we test the law by saying
But
that
who volunteer to die before their child is born and do a will?
well, I was trying to stretch the argument to where anyway, it might not be illegal because if I am diagnosed to not to live by the time that I expect a child to be born to me, I can't make a will, can I?
But these are all preemptive thoughts. If, or you may not. There are people who are fortunate enough to go beyond the may not.
Okay.
But if you certainly know that you may not, then of course you can say that, okay, as part of my will, I'm giving my right as a birth citizen to my child, so that when my child is born, they should effect the right within the rules to ensure that the child has been passport has been given to the child. But then we have to then go through the process. You can say this will be a long battle in terms of core argument. Because the Secretary of State will also, because this has maybe not happened before. That's why we don't have it anywhere within the statute books. So we don't have a template to even
Think of that.
follow through.
Yes, it's been a very lovely discussion, but listen, I would need to get to my quiz as well because that's another interesting segment coming. We have been discussing how to successfully apply for a British passport for your child born abroad and living abroad. Thank you for your questions. Thank you for your questions and concerns and your contribution, and also staying along and making sure that we have some wonderful audience for our discussion. Lawyer Charles Asma from BWF Solicitors has been doing the lead discussion for us, and we're so grateful to BWF Solicitors. Now, next, it's between you and I. What are we going to do? I'm going to ask you a question. From the beginning, I asked you to get your calculators and your pens and papers ready, your pencils and papers ready, because I'm going to get you to do some mathematics for me. Are you ready? I'll be back after this. So take the question, then I'll take a break. By the time I come back, you would have calculated everything for me. Equia Mavis is off sick from work from Monday to Wednesday of the following week. Equia Mavis is off sick from work from Monday to Wednesday. So there will be 2 Mondays in here and 2 Wednesdays in here. Why am I giving you a clue? Anyway, her contracted days are Monday to Friday. Her period of sick leave is a total of 7 qualifying days. Look at the scenario again and carefully. Equia Mavis is off sick from work from Monday to Wednesday of the following week. Her contracted days are Monday to Friday. Her period of sick leave is a total of 7 qualifying days. Please calculate the period for the statutory sick pay to be paid. I have 3 answers for you. It will be £109.40 divided by 5 and multiplied by 4. Or £109.40 divided by 5 and multiplied by 5, which will give you £109.40. Or 3, £109.40 divided by 7 and multiplied by 7, which will give you £109.40. You see, there are 2 answers that are the same, but the scenarios are different. £109.40 divided by 5 and multiplied by 5, or £109.40 divided by 7 and multiplied by 7. The first one is totally different because it's giving us a different answer, but it's still based on the £109.40 divided by 5 and multiplied by 4. Now let's go to the nuggets, and I'll tell you why I'm giving you this question. Now, it's about statutory pay, statutory sick pay. Statutory sick pay is a legal minimum payment staff should get when they are off sick, that is, incapable of work due to sickness or injury if they meet their eligibility requirements. For the tax year beginning April 6, 2023, the rate is £109.40. The previous rate was £99.35 per week. So remember, the £109.40 is per week. It is usually payable from day 4 of a sick absence. During the COVID pandemic, SSP was payable during periods of self-isolation, provided the employee met certain eligibility criteria. However, these laws have now been removed. The statutory sick pay regulations of 1982 as my source. I'll be right back.
This is our world. Here we are in our community. There are the laws, there are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, now have you finished working? Can I can I see your answers? Let me go back to the question and I'll go through it again. Laura is here, he's going to help us do that calculation, don't worry. But give it a try. Let's see how it goes. Aquia Mavis is off sick from work from Monday to Wednesday of the following week. So Monday, Tuesday, Wednesday, Thursday, Friday, 1 week. Another Monday, Tuesday, and Wednesday. That makes it 8 days. Or even if you don't count the previous Monday or the next Wednesday, it's 7 or 8 days. Let's look at that. Now, when you look at the nugget, it says that your statutory sick pay starts from day 4 of your absence, day 4. So let's look at when Queer Mavis or Afia Mavis or whoever, what's the name? Queer Mavis went off sick. Monday, Tuesday, Wednesday, Thursday. When does this statutory sick pay start? I won't tell you. But Friday, Monday, Tuesday, and Wednesday. That makes it 8 days. So, how much is the pay going to be? Is it £109.40 divided by 5 and multiplied by 4? Or £109.40 divided by 5 and multiplied by 5? Or £109.40 divided by 7 and multiplied by 7? Tell me your answer. I'm waiting. Is it easier or difficult or confusing? Where are you? Tell me. You can text 0739920848 or send a WhatsApp to 0795042270 or put your answer in the comment section below, either on Facebook or YouTube. Let's see what you have. Ooh. When it comes to mathematics, everybody is right now, yeah? The next thing says it's very deep. Yes, it's very deep. I need you to calculate it to go on. So the next thing go on. It's very deep, I know. What's your answer? Or no, but I think I tried to give you a clue. Can I go to the nugget again and tell you? It says that statutory sick pay is usually payable from day 4 of a sick absence. Aquia Mavis went off sick from Monday, Tuesday, Wednesday, Thursday, Friday, Monday, Tuesday, Wednesday. And going to be paid from day 4. Monday, Tuesday, Wednesday, Thursday, we don't calculate statutory sick pay from there. But from day 5, Friday, Saturday, oh no, Friday, Monday, Tuesday, Wednesday. How many days there? Okay. I won't say anything again. Now I'll give you answers. 0739920848. 0795042278. That's for WhatsApp. So you can call on WhatsApp or text on WhatsApp. That's fine. Nigeria is not deep. Please come. Ademo Ninkum says is number 2. £109.40 divided by 5 and multiplied by 5. Okay. So if we divide by any number of days, then it means that 1 day. Okay. Now, multiplied by the number of days, how many days does a queer have to be paid statutory sick pay? I think I'm even giving you the answer now. Okay. Lawyer, let me bring you in. People are finding it confusing. Bring your math skills here. Okay.
Right. So we are told that a queer works Monday to Friday. A queer, in terms of sick leave, qualifying period is 7 days. But we know that within the 7 days, there will be weekend. And weekend is weekend, whether you are sick or not. No employer will pay you to sit home on Saturday and Sunday. So we are looking at the working days. We are also told that the paying period starts from the 4th day. The 4th day. So a queer is going to be off sick the following week. So the following week, Monday to Wednesday, she's going to be off sick. Payment will be from the 4th day. So if we are calculating, we have the standard 5 days, which is Monday to Friday. But in terms of the qualifying period, we are looking at starting from day 4. So if you look at the third one, it says 7 out of 7. If it's 7 out of 7, then it appears that it starts from day 7. The second one says 5 out of 5. 5 out of 5, it will appear as if a payment starts from day 5. The first one says 5 out of 4. It appears payment starts from day 4. The rules say that payment starts from day 4. And there are 5 working days or 5 days in here. Therefore, if we do the calculation, you realize that a queer is going to be paid the standard one, which is 109, plus some day bit, but it's not going to be full day. And therefore, we have to divide 5 by 4. If we divide 5 by 4, we're going to get 1 point something. So 1 point something, if you work it out, you multiply by 109, that will give you 109 plus some money to make the fraction of more than 4, because it's not up to 5. So in this case, we have more than 5. If you do your math, it's 5 divided by 4, you multiply by 109, and that will give you about £136 for that week that she's going to be absent. Otherwise, if you do 5 over 5, she's going to lose out because she's only going to get the 109. If you do 7 over 7, she's going to lose out. She's going to get £109. But if you do the fraction properly, you realize that she get a full day plus the extras, and that will give her more than £109 for that week. And that will be the conclusion.
So in this,
the answer is A.
The answer is A. Okay. Yeah. When I was trying to pull the question together, I was insisting, I was calculating the days, and that's exactly what you have helped us do. Because one, it's not 5 days. It's not 7 days. So obviously, if I was guessing, I would go for the 4, and with your explanation, add a little bit. It's not up to 5, but it's more than 4.
More than 4.
So then, for that week, up to the Wednesday, you take the 4 days out, and there will be 4 days and some extra hours left. So for that week, Akuya maybe is going to get 136 pounds something. But the following week, if it's a full week, then it's going to get a 109 pounds, isn't it?
So we are told that she will be off sick the following week. So what it means is that she's potentially served the sick note, and the doctor has approved for her to be off 3 days next week. So next week she's not going to come to work, but the employer is also going to take a pound of flesh by saying that we are not going to pay you your full salary for the week. We give you the minimum the law says we should give you. So we are going to calculate that, and we are going to start from day 4, because so you are going to be off Monday to Wednesday, but the calculation will not start from Monday, Tuesday, or Wednesday. To start from Thursday. And therefore, if you look at that, the 4th day, so the 4th day she's going to be paid, then the 5th day she's going to be paid. But you can see that if you do the calculation, it will give you the 409 plus the remaining bit. It's a technical area of computation, but all you will want to understand is that where does it start from? Day 4.
Day 4.
Okay.
And that's
then divide by day 4, multiply by the number of days that she's supposed to work for. Yeah.
Well, that's it. And you didn't need to crack your brains too, and at least take the day 4 bit and remember that. So whenever you start your sick leave and you're supposed to be paid for that, make sure you start your calculation from day 4. As she's not entitled to be paid for the first 3 days, she will be eligible for SSP for 4 days. To calculate SSP, you need to take the weekly rate, which is £109.40, divide this by the number of qualifying days in a week, and multiply by the number of days for which an employee is entitled to SSP. So the answer, as Laura has explained, is 109.40 divided by 5 and multiplied by 4, and that will be 100.
The other way around.
Well, divided by 4 and multiplied by 5, and that will be £136.75. Well, with that, I will go back to Lawyer for him to do the summary of our discussion this afternoon for us. Then we'll draw the curtains down.
Thank you very much, viewers and listeners. So, British passport can be issued while the child is still overseas. It is the simplest way to say that my child is British, even if they have not stepped foot to the UK before or in the UK before. Now, how do I prove that? I have to show that I'm a parent, I'm a British citizen at the time my child was born, and I did not acquire my citizenship through my ancestral route. In this case, you have to prove that you are the parent, birth certificate. You have to prove that you have your naturalization, you got it before the child was born. You have to show that the mother of the child actually conceived the child, and there's evidence of hospital records showing pre and post-natal activities. And again, there should be evidence that confirm that you are in the life of the child as a responsible parent, so to speak. Even though this is not a statutory provision, they want to be sure that there are safeguards in place, and such safeguards include you, the parent, proving that your child's mother actually became pregnant for you, and this is the outcome, being the child, and that you were actually involved in the life of the child as a responsible parent, and therefore you have that as well to go through. Once all this is done, you can then apply, put in the necessary application form, OVS, Overseas Passport Application Form. You complete, you add the document, and you submit, and you pay a fee. The fee is under £100, so it's not a big deal in terms of the fees. If you are doing it yourself. If you are not doing it yourself, then of course you employ the service of a lawyer, and the lawyer will charge their own fee. And that
all the documents will be sent to the passport office, will be processed. The parent in the country, the home country, will be asked to attend, or the parent making the application for the child will be asked to attend interview. An interview is usually done by Zoom. Just like everybody goes through interview when they apply for passport, the parent will be asked to attend interview. What will the interview be about? To confirm that they are indeed the parent of this child. They became pregnant for the father who is applying for passport supposedly for the child, or if they are applying for the passport themselves, yes, the mother actually became pregnant. So they will ask all these questions, and once they are satisfied, the passport will be issued. Once it's processed, it's sent to you. All your documents will be posted back to you in the country where you are. Can it be done in the UK? Yes, we do a lot in the UK, and therefore, if you need our assistance, look no further. Come in. We'll start from day one and finish for you within the next few or days or weeks, and you'll be smiling. Thank you.
You'll be smiling, and that smile will be so broad, left to right, and all over you. When you deal with BWF Solicitors, BWF Solicitors, thank you very much for your sponsorship, for your time, and for the resource that you share with us every day. So, folks, if you need a reliable law firm, it's BWF Solicitors on the 4th floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters, North London, N15 4NP. Call them Monday to Friday between 9:30 in the morning and 6 p.m. in the evening on 0208 493 7340 0208 493 7340. BWF Solicitors helped us to bring you this wonderful program. And let me first of all say thank you very much to Lawyer Charles Asma for spending time with us this afternoon to take us through this very technical discussion, how to successfully apply for a passport, for a British passport, and so a British child that was born and is a living outside of the UK. And also, he helped us do that wonderful calculation. And I know so many people didn't want to try because you don't want maths. No worries. Whatever it is, you can trust BWF Solicitors to help you do that. So BWF Solicitors, we salute you and say, God bless you. And we'll be back again, obviously, for more. And on behalf of my studio producer, Professor Ade, who makes life so very easy and reliable for me, and to Sheila Ankra and Padmo Dudu for doing the aesthetics and the administrative work, to Uncle Ben, Lawyer Charles Asma, Lawyer Eunice, and to Cynthia, and all the other wonderful people of the BWF Solicitors family, both here in the UK and Ghana. We say thank you very much, and we want to meet you again, same time next week on the same platform. It's going to be the community and the law. Good evening.